Good afternoon, everyone. Welcome back after lunch. We have a great lineup for the afternoon, and our first speaker is going to be talking about the importance of whistleblowing. He is Professor Emeritus at American University, Washington College of Law. He has been a scholar in residence with the law faculty of the King's College of the University of London. He has also been a visiting professor at Monash University in Melbourne, Australia, and he has taught at the University of San Diego School of Law, as well as a visiting professor at Ritsumeikan University School of Law in Kyoto, Japan. Please welcome Robert Vaughn.
Thank you very much. As a teacher, I was always a little concerned when I was assigned that first class after lunch, but we can move from there. One Australian observer of whistleblowing concluded, "Whistleblowing is the legal regulation," and I quote, "most crucial to integrity, accountability, and organizational justice in all institutions," end quote. Even if you might be a little skeptical about that statement, which, by the way, I am not, we recognize that whistleblowing is a powerful technique for holding the powerful accountable. I will describe the importance of whistleblowing law by examining several different perspectives that are linked to different frameworks of accountability. These perspectives are a reservoir of arguments and proposals for change. Through them, we can consider the history and the expansion of whistleblowing laws and breaking through power. But I can't begin this discussion without mentioning those whistleblowers who have changed the perceptions of the public of whistleblowing and who have established the context and content of many whistleblower laws. But without an appreciation of these persons, whistleblowers become kind of insubstantial legal creations. An appreciation of their accomplishments and sacrifices make whistleblowing concrete rather than abstract, personal rather than statistical, and emotional as well as analytical. I will not forget them as I speak, and I ask that you do not. We're going to discuss these four perspectives: the employment perspective, the open government perspective, the transparency or market regulation perspective, and human rights. The New Deal labor reforms in the 1950s developed an anti-retaliation principle that prohibited retaliation against employees for disclosure of violations of labor laws or workplace protections. In the 1950s, a few courts, particularly those in California, used the anti-retaliation principle to restrict dismissals of at-will employees when those dismissals would be against public policy, because those employees reported violations of law by their employers, violations of both regulatory and criminal law. This history helps to explain why whistleblowing laws are usually treated as a subset of employment laws. The character of modern society also explains this conception of whistleblower laws. The activities of contemporary society rely heavily upon the activities of government through government agencies and the activities of private organizations through corporations. Both private and public sector organizations can vary in size, but except for the smallest, they require employees to carry out their activities. These employees possess information not otherwise available regarding misconduct, incompetence, corruption, and dangers and risks connected with the organizations that employ them. Employees and employers, therefore, may properly see whistleblower laws as changing the relationship between them. If whistleblower laws restructure the workplace, this reduction in the power of employers invites widespread and lasting opposition to these laws. This perspective invites the consideration of the interests of employers, who can argue that it is the public interest, not the interest of employees, that must be considered. Thus, it is the employee who must prove the entitlement to protection, and the employee does this in a setting where they normally face the resources of the employer alone. The other perspectives are information-based. The employment perspective is not. In the employment perspective, the emphasis is on the employment relationship, and that relationship incorporates interests in bureaucratic secrecy, secrecy that is asserted to be justified because of the need for rational decision-making and the preservation of management prerogative. This perspective contains other difficulties as well. It incorporates the procedural and administrative mechanisms of employment. These administrative and procedural mechanisms usually benefit employers. It requires the determination of who is an employee, and it requires the determination as to whether retaliation takes place through an employment-based action. Both of these requirements invite subterfuge and abuse. It is less likely than the other perspectives to draw on international law and on international organizations. International labor standards are ambiguous as to whether employees who make disclosures that do not involve violations of workplace laws are protected. And the International Labor Organization lacks the status and influence of international human rights and anti-corruption organizations. Because of its pervasiveness, the employment perspective is a powerful alternative to the others. The open government perspective. This perspective emphasizes the public right to know about government policies and practices. Freedom of information laws offer the justifications for disclosure of information held by the government. A principal justification for this disclosure is sustaining democratic accountability. Democratic accountability involves both political accountability and legal accountability, and open government laws support both types of accountability. As to political accountability, ignorance of the action of government officials makes criticism of the government less likely. Ignorance dulls outrage and reduces the likelihood that civil society groups will organize and use democratic procedures for change. As to legal accountability, the accountability of government officials, on the one hand, requires an understanding of the standards and practices that are to guide their conduct, and on the other hand, requires information about the conduct of those officials. The open government perspective introduces a dispute about the role of government. One view of the role of government is a limited view that in order to preserve the realm for private activity and choice. The other, more activist view of government says that the democratic state must address societal maladies that individuals are unable to resolve. The activist view sees the individual at risk not only from government, but from the concentration of private power from which the individual must be protected by the government. Both views identify corruption as a threat to the mission of government. The open government perspective affiliates whistleblower protection with international anti-corruption movements and that also advocate democratic accountability and disclosure. In contrast to the employment perspective, the open government one is information-based. Nothing in this perspective necessarily requires that protection apply only to employees. The market regulation or transparency perspective. This perspective evidences a concern with open markets. For example, with the flow of capital internationally, it requires an assessment of political risks and argues for knowledge of the frequency of corruption. The lack of transparency of markets or of government can be a surrogate for the likelihood of corruption. Corruption distorts markets. For example, corruptions in government contracts distort not only domestic markets, but can distort international markets as well. Whistleblower protections are information provisions that help to support efficient markets. Such whistleblower provisions thus become part of anti-corruption efforts in many countries, in international conventions, and in international economic organizations such as the World Bank and the regional development banks. Although concerned with the protection of markets, this perspective implicates misconduct by government officials as well, as the open government perspective can apply to non-government disclosures. The market regulation perspective can encompass information about government. These protections need not apply to employees because Hello? Oh, it's back on. Okay. Either that or my voice suddenly disappeared. I wasn't sure which. The protections need not be limited to employees because a number of individuals possess information relevant to the evaluation of markets. For example, the Inter-American Convention Against Corruption extends its protections for disclosures to, quote, public servants and private citizens. The breach of fiduciary duties by corporate officials often involve the suppression of information or the presentation of false information. This concealment and falsification of information distorts markets, particularly markets in corporate securities. While the open government perspective can be seen as an information-based approach to the accountability of government, the market regulation perspective can be seen as an information-based approach to the accountability of markets. In response to the Great Depression of 1929, the New Deal used information disclosure as a method of market regulation. Two recent examples emphasize this approach and the increasing importance of whistleblower protection. The Sarbanes-Oxley Act responded in the whistleblower provision to the failure of Enron and WorldCom, failures that were caused by accounting fraud. One of the best-known whistleblowers of the period, Sharon Watkins, who was named a Time Person of the Year along with Cynthia Cooper, who was another corporate fraud whistleblower, sought to inform corporate officials of these fraudulent practices. Unfortunately for her, all of the officials she approached were deeply involved in the fraud. The legislative history of the whistleblower provision of the Sarbanes-Oxley Act refers to this role of Sharon Watkins. The financial crisis of 2008 led to whistleblower protections in the Dodd-Frank Act. The provision contained important innovations and reflected the importance that was attached to whistleblower protection as a regulation of markets. Health and safety regulation, in the view of many, reflect an importance beyond the integrity of financial markets. The loss of human life and human suffering of these deaths and injury demand effective regulation of health and safety. The inadequacy of industry standards in industry after industry has generated a wealth of statutes. The information disparity between regulators and regulated industries is accepted as a principal reason for regulatory failure. This information deficit disables regulation. Beginning at least with the Mine Health and Safety Act of 1977, whistleblower protection has been used as a tool for ensuring adequate information regarding workplace risks or public safety through protected disclosures to regulators. Many environmental and health and safety statutes contain whistleblower protections. Important whistleblower provisions are included in the Consumer Product Safety Improvement Act of 2008 and the Food Safety Modernization Act of 2011. Since 2000, Congress has enacted or significantly amended more private sector whistleblower provisions than in any comparable period. Federal private sector whistleblowers laws now cover tens of millions of private sector employees. The human rights perspective. Freedom of expression has played an important role in the development of whistleblower protection in the United States. In 1968, in Pickering versus Board of Education, the United States Supreme Court applied the First Amendment to protect public employees who made disclosures to the public. The whistleblower provision of the Civil Service Reform Act that covers millions of federal employees sought to vindicate these constitutional rights, but it substituted statutory standards for the vague balancing test under the First Amendment. In this sense, U.S. whistleblower law rests on the human right of freedom of expression. This perspective gives whistleblower protection a strong connection to international human rights law. For example, both Article 19 of the Universal Declaration of Human Rights and Article 13 of the American Convention on Human Rights protect freedom of expression. The right has been broadly interpreted by the Inter-American Court of Human Rights. In Reyes versus Chile, the court held that this right of freedom of expression gives the individual the right to receive information about the government and imposes upon the government an obligation to provide information to citizens. International human rights contains a large body of ideals, principles, and arguments. Powerful international organizations support the development of human rights. Under many human rights conventions, signatories are bound by the decisions of judicial bodies who are charged with interpreting the convention. For example, decisions of the European Court on Human Rights have helped to develop human rights in Britain, whistleblower rights in Britain. A human rights approach relying on freedom of information is more likely to encompass opinion. Therefore, this perspective supports a broader scope of protections and under more lenient standards than reasonable belief. The freedom of expression applies to public disclosures, and this perspective, more than the others, is likely to protect public disclosures. The principle of the indivisibility of human rights would protect disclosures addressing other fundamental issues of human rights. The human rights perspective is not instrumentalist, as are the other perspectives. With them, protection is granted to serve some other value or interest. A human rights analysis focuses less on human rights as a way to implement other values or to accomplish worthwhile goals, but asserts that these rights represent basic human values worthy of protection. The task of breaking through power is not an easy one. Whistleblower law is often seen as a way of doing so. To understand the weaknesses of whistleblower law, but more importantly, to appreciate their possibilities requires an understanding of these perspectives. Because of these perspectives matter, examination of them helps us to see the weaknesses of whistleblower law and to appreciate possibilities for change. Each of these perspectives enables and limits whistleblower protection, and examination encourages us to seek significant change. By the way, for the students here, I'd like to give a little warning. And that warning is be very careful what you do when you're 26 years old. When I was 26 years old, I turned down a couple of jobs and took a job with Ralph Nader in Washington. And one of the tasks that he charged me with was looking at the federal civil service. And one aspect of it that I came to particularly focus on was the need for whistleblower protection for federal employees. So now, some 40 years later, I'm still working on the same topic that I was assigned then. So just an alert, please be extremely careful what you start with when you're 26 years old. Thank you.